afternoon, everybody. My name is Oliver Westmoreland. I am an OSC registered Level 3 Immigration Advisor, and I am also Senior Immigration Lawyer with GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so that you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today's topic is this: visa application refused. Should you reapply or should you challenge? It's quite a large topic. I'm going to do my best to explain it in a simple way. Migrants apply for things. They apply for visitor visas, they apply for working visas, they apply for family visas, they apply for European visas, they apply for all kinds. Might be successful or unsuccessful. If the application is unsuccessful, you will always have a right of challenge in every single case, but the type of challenge varies. If you apply for a working visa or a study visa, for example, it's refused, you'll have the right to administrative review. This is a process with the Home Office or UKVI, UK Visas and Immigration, whereby a more senior official in those organisations assesses the decision made by a more junior caseworker and decides whether the decision was good or bad, fair or unfair. If the decision was wrong, then the decision is reversed and you get the visa. Other areas, it's different. Family visas, partner visas, child visas, adult dependent relative visas, things like that. If the application is refused, this could be in country or out of country. If the application is refused, there is a right of appeal to the first tier immigration tribunal. This is a rather deeper process. Also, for example, applications for settlement on the basis of 10 years continuous lawful residence, again, right of appeal if it's refused. Similarly, applications for private life, so-called private life rules in the immigration rules, whereby someone has lived in the UK unlawfully or partly unlawfully for a long period of time, maybe years, they apply for limited leave under the private life rules, refused, there is the right to appeal to the first tier tribunal. And of course, asylum seekers, people who claim asylum, refused. In, I would say, almost every case, there's going to be an in-country right of appeal for the first tier tribunal. There are a few strange categories. Visitor visa application. Now, do know, in every case, a visitor visa application has been made outside the UK. You can't make a visitor visa application inside the UK. If it's refused, there is always a right to challenge, but the rules are a bit funny. There is no right to administrative review. There might be the right to appeal before the first tier tribunal, but only if it's a real family type visitor visa application, like parent to visit parent, parent to visit child, child to visit parent, something like that. Otherwise, there will be no right to appeal. The only recourse will be judicial review, which is something a bit special before the upper immigration tribunal. It's like a very small appeal hearing. So let me, before we get too deep into this, let's summarise. There's always the right to challenge. Usually, it'll be by way of administrative review with the Home Office or UKVI. In many cases, it'll be by way of appeal to the first tier immigration tribunal. In just a few cases, it'll be by judicial review. If your visa application is refused, what should you do? Should you challenge? Or should you just give up? Say, okay, I'm going to make a fresh application. It's a very, very good question indeed. Things that have happened recently have an impact. Back in older times, administrative review was quite quick. You got your decision in about 3 or 4 weeks on administrative review application. Traditionally, it was much longer than appeal because everyone knew appeal took ages and ages and ages, months and maybe 1 year. However, in the last few months, something strange and unfortunate has happened. Administrative reviews have slowed right down. According to the Home Office's own website, sometimes can take 12 months to get a decision. Now, this is a bit silly, really, because, you know, let's say you applied for a working visa or a study visa, it's refused. You think, oh, I want to challenge that. You know, this is not fair. and there's a 12-month waiting list. Well, in 12 months' time, everyone might have died who's involved in the case. The job might have gone. Your course might have finished. It produces a very confusing situation. Now, with appeals, it was always like this. There was incredible delays. It might not be worth it. You might as well rip it up and start again. This has now become true of administrative review as well, and sometimes administrative review issues are more time sensitive, so this is something you have to bear in mind. Should you challenge, should you reapply? Judicial review is probably now it's the fastest, faster than appeal, faster than administrative review. That's the thing. Is it going to take so long? It's not worth it. You might as well start again, afresh. Other issues, however, could be very important. If you have been accused of dishonesty or deception in the refusal decision, reapplying may be not a good idea at all whatsoever. That allegation sticks on your record unless you have it challenged and wiped off. If you haven't challenged it and it hasn't been wiped off, it stays there. So, of course, when you reapply, that allegation is still on your record, almost certainly you're going to get refused again. So for that reason, you might want to challenge the decision rather than reapply. That's a broad outline, Mr. Shah. I'm sure you have a few interesting questions for me.
Yes, thank you very much for going into this topic, because whenever someone's visa is refused, they're all often confused. What do we do next? Can we do administrative review, or do we do appeal, or we just reapply? It's good to know that, how long currently the administrative reviews are taking, so one could possibly decide to just make a new application perhaps. When making a new application, can the applicant introduce more information that may be related to previous refusal and address those issues in a new application?
Not a great deal, because the time to address those issues was when you had the time to challenge. You can try. It may not go very far. You've left it too late.
Sure.
Probably.
And am I correct in assuming that not every application that is refused is challengeable?
No, I think there's a challenge in every single case. Usually by administrative or appeal or possibly judicial review, there is always a right of challenge. Judicial review is like, I know that you play cricket, Mr. Shah, at weekends. You have a long stop.
Yes.
The ball flies high over, person right at the end of the field catches it, long stop. Judicial review is sometimes called a long stop by those who are keen on cricket. If you've got nothing else, or if everything else fails, let's go a bit broader. If there is no right of appeal or administrative review or anything, there will be a right of judicial review. If you've used everything else, there's a right of judicial review. For example, administrative review. If it's unsuccessful, there's an onward right to judicial review. There is always an initial right of challenge, but I would say judicial review is a bit dodgy. A, it's not a very strong remedy, and B, if you lose, you can pay an awful lot of money in loser's costs to the Home Office if you lose. So
True.
It's not good in that way, but sometimes it's all you've got. Appeal is better. The rate of success for appeals is higher than for administrative review, and I think I know why, probably. With administrative review, the same organisation that makes a decision on the decision. It's the same sort of people who assess the decision made by the other people. Appeal, quite different. Immigration judge is not employed by the Home Office. They are employed by the Ministry of Justice. They don't know anyone in the Home Office, not as far as we know anyway. It's a more independent process, not necessarily slower anymore, but it's probably going to be a lot more expensive appeal than administrative, because you're probably going to pay lawyers to prepare case and prepare witness statements and everything. But really, let's say administrative review is a averagely good remedy. Appeal can be very good remedy, more expensive. Judicial review, well, some things are different. You have to get permission to go for judicial review. If the upper tribunal think the applicant is rubbish, you just get refused. Appeal, you can do it and see how it comes. Judicial review has that. And also, as I say, if you should lose, you can get hit by a big bill from from the Home Office.
Can be very expensive.
Yeah, it can be. And also your lawyer's going to charge quite a bit as well, because some of these cases are complex. Some of them require legal representation before the upper tribunal.
True. And assuming someone goes for appeal, if the appeal is dismissed, will I be correct in assuming all the appeals have the chance to seek permission to further
appeal against the
first tier tribunal?
Yeah, you can. Well, it's slightly complicated. Let me put you short and straight. Your appeal before the first tier tribunal is unsuccessful. You can apply on the basis of what you think is an error in the decision. You can apply first of all to the first tier tribunal. Say the decision was wrong. We think there's an error. If unsuccessful, you can reapply to the upper tribunal. Now, upper tribunal does two jobs. It does judicial review and it does appeals against appeals in the first tier tribunal. You can try a second time, a second bite of the cherry, as they say, with the upper tribunal. But again, ultimately you need permission. If you can't get permission, the appeal against the appeal does not happen. I mean, unless you've got strong grounds, it's not worth it. They're quite merciless, those judges who decide that.
True. So it's only worth doing if there is real chance of
success.
Yes.
You're going to spend money with lawyers, no doubt. It is difficult work. Unless there's some reasonable chance of success, probably you're going to be wasting your money.
Sure. And the appeal can be, of course, done outside the UK or inside the UK.
Yes.
The processing time for appeal, more or less...
The tribunal is always in the UK. It's not outside.
Yes. Yeah. So there is no tribunal for the UK outside the UK. They're all inside.
Yeah, correct.
And, of course, anyone even outside the UK can instruct a UK lawyer to represent them.
Probably best to instruct a UK lawyer. Don't instruct some sort of foreign lawyer who may not know all the rules and all the law and everything.
Or the agent.
Yeah.
Okay, and the processing time for appeals is more or less the same from inside and outside the UK?
I have a feeling it's quicker inside the UK. This has had a feeling over many, many years, and we formed a reason. We thought the Home Office doesn't really care about people who are outside the UK so much because they're not here. It cares more about people in the UK and sort their situation out more quickly. Possibly a bit quicker in the UK.
It is about 2 to 3 months on average. We see it's quicker in the UK.
Well, to get the hearing there, it takes a long time. You've got to go through all these different stages and papers. They've introduced a quite sophisticated system now. They require the Home Office to really make sure that they mean to refuse the application.
True.
They're given every opportunity to withdraw the decision, which they didn't have a few years ago. They've made it in such a way, maybe make it a bit longer, but actually good for migrants.
True.
They have to say, are you really sure you want to maintain your decision?
Yes.
Moving on a bit, if they maintain the decision and the decision was poor and they lose, your client can sue the Home Office for unreasonable behaviour, wasted costs order.
Nice.
Now this is going into another topic, but don't forget they're introduced. This is quite sophisticated.
Nice. That's good to know. That's very good for the appellants. I wonder how many people actually do it.
I think a lot of people don't know, or their lawyers don't know. But in GSN immigration, we know.
We know. Perfect. Awesome. Well, thank you so much for elaborating on this topic in such detail. I'm sure the viewers will find it very useful.
Let's hope so.
And we see you in the next one. Inshallah.
See you next time.
See you next time.